Welcome to Prediction News Update. I'm Chris Gerlacher, the senior political reporter and industry analyst for Prediction News. And today we've got Daniel Wallach, appellate lawyer extraordinaire, with us to talk through Maryland. Dan, how you doing?
Doing great. I thought it was sports betting appellate lawyer extraordinaire last week. I lose the title. I guess you broadened it. It's now just overall appellate lawyer extraordinaire. So I guess I'll take the enhancement for sure. Thank you.
Yeah, well, we're well outside of sports betting now, so we're gonna may have a grander title to match. So today I want to ask you about the tribal brief in Maryland. Then we'll go through Maryland's reply brief, Kalshi's reply brief. So we're not just talking about the opposition all the time. And then I want to end with the timeline for a judge's decision and the consequence of Kalshi either winning or losing this case. So let's start with the tribes. I mean, I know they filed already in the Third Circuit in New Jersey. How does this tribal brief compare to that one?
It was largely the same brief. I mean, if you read the Third Circuit brief side by side with the amicus brief filed in Maryland, they're almost indistinguishable. Yeah, maybe the Maryland brief is a little bit shorter for the reasons of trying to get it over the finish line, because it's not a certainty that the court will accept the tribe's amici brief in Maryland. They received consent to file it in the Third Circuit, so they could go on for as long as they wanted. But here, it was opposed by Kalshi as both being untimely and unhelpful. So what the tribes did was they presented basically I wouldn't say a Cliff Notes version of it, but a slightly truncated version of their Third Circuit brief. I thought it was an important submission because the state of Maryland hasn't really argued IGRA. And while IGRA is mentioned in the Maryland submissions, it is done so in only a passing fashion alongside the Wire Act and PASPA, as sort of providing a indication of congressional intent that sports contracts weren't intended to be part of the Commodity Exchange Act. But it was never argued by Maryland that the contracts themselves would violate IGRA to the extent that traders purchase and sell these contracts while they're in Indian land. So with the tribal organizations, I think it's 27 tribes, 7 tribal associations, which are like trade groups, they elaborated on their forte. I mean, they are experts. The gaming lawyers that presented this brief, some of the leading tribal gaming attorneys in the United States, and they forcefully presented the various reasons why they believe that Kalshi's contracts interfere and run roughshod over tribal sovereignty in violation of the Indian Gaming Regulatory Act. And the main argument is that to the extent that these contracts are offered for sale and purchase while a trader is located on Indian land, it's a square away IGRA violation, because IGRA, which is a federal statute, guarantees that these compacts approved under state law are protected by federal law. And one of the component parts of almost every single tribal gaming compact is having exclusive rights to offer and to regulate gaming on Indian lands. And to the extent Kalshi's contracts are available on Indian land, well, that interferes and violates tribal exclusivity, which is bargained for as part of these contracts in exchange for the state getting a revenue share.
Sure. Can the courts find that these contracts constitute gaming if the CFTC doesn't, or does that have to come from the CFTC?
In the hierarchy of legal authority, mere federal agencies are here, courts are here, appellate courts are up here, the Supreme Court is up there. Okay. An Article 3 federal district court judge is empowered to interpret whatever the laws are, be they statutes, constitutional provisions, or agency regulations. I think that's one of the misnomers that Kalshi may have been advancing in some of their litigation papers, that to the extent that Maryland or any other state agency is claiming that these sports event contracts violate the CFTC prohibition against gaming contracts that's enshrined in Rule 40.11A1, well, that's the agency's call to make, not a court's call to make. But Maryland has argued, and I think convincingly so, that if you have a categorical, across-the-board blanket prohibition against these contracts as being against contrary to the public interest, and you decided that issue 14 years ago by promulgating Rule 40.11, the agency is without jurisdiction to make any determinations as to whether these contracts should be allowed, because they have already made that categorical determination 14 years ago. And this issue keeps popping up time after time in all three lawsuits, but particularly in the Maryland case, where Kalshi is advancing the argument that the CFTC remains empowered to do a case-by-case public interest review as part of a two-step determination. Step one, is it a contract involving gaming? And here, Kalshi has finally openly admitted that these contracts are gaming contracts. But Kalshi responds to that by saying, well, under the second step of the two-part analysis, the agency, the CFTC, can still determine that these contracts are not contrary to the public interest, especially in view of the fact that in the post-PASPA environment, 38 states plus the District of Columbia allows sports betting. So it is actually within the public interest to have a more liberalized view of the permissibility of gaming contracts. And of course, Maryland says, well, you said no to that categorically 14 years ago, and that rule is still on the books.
Mm-hmm. Yeah, well, the interesting thing about Maryland's case was, or Maryland's brief, was how heavily they relied on Kalshi's own words in the district case. I thought they made a pretty compelling argument, especially near the end of that brief, where they're saying, "Hey, we've interpreted the same statutes the same way in the DC case, so let's just extend it forward." But they're not leaning as heavily on the judicial estoppel anymore, are they?
No. But they have the advantage. Maryland really is exploiting the advantage of being third in the queue. Mm-hmm. If you're batting leadoff, as Nevada was, you don't have any prior work product to lean on. Maryland has actually had the benefit of reading all these other briefs filed by New Jersey, Nevada, and all the amici that filed in the New Jersey and the Nevada courts. And they've actually taken a deep dive and carefully combed through the DC Circuit litigation over political event contracts from last year. They read every brief, did a text search for every time legislative history has come up, and every statement that Kalshi made to the effect that Congress did not want sports gambling to be conducted on derivatives markets. And they kept pointing to that colloquy between Senator Feinstein and Senator Lincoln, and took it a step further and asserted that there's no potential or no economic, commercial, or financial consequences associated with the sporting event, that they're without any economic consequence or commercial or hedging utility, which is a far cry from what they're arguing now. And Kalshi has been, called on it by Judge Abelson in the preliminary injunction hearing. So what their mission was in their supplemental briefing was to try to explain the inconsistency of the two positions, why they argued what they did in DC, and why they're arguing what they're arguing now in the Maryland case, and why that should not constitute a judicial estoppel. I mean, in the DC case, they were arguing over, the battle was over whether political event contracts involve gaming. Sports betting wasn't part of that case. It wasn't central to that case. And it really is a fine line as to whether their statements that were inconsistent as to sports betting drove the result in the DC case. Kalshi says, no, it doesn't. It had no influence or impact on why the court found political event contracts not to constitute gaming. And of course, Maryland takes the position that the reason why they argued sports betting as not being part of Congress's intent so vociferously in that case was that in the prior case, Kalshi was urging a very narrow interpretation of the gaming category, and that the gaming category only encompasses sporting events such as the Kentucky Derby, the Masters, the Super Bowl. So in order to persuade the Washington DC Federal District Court to apply a very narrow construction of the word gaming, Kalshi had to contrast political contracts with all of its vast economic consequences with the Masters, the Super Bowl, the Kentucky Derby, which have no macro economic consequences that turn on the outcome. And those are the competing views offered by Kalshi, that it wasn't central to the argument in the Washington, D.C. case. And what Maryland does is very clever in this case. I think they realize it's a borderline judicial estoppel argument. So on the one hand, they're arguing why this case should result in a judicial estoppel that binds Kalshi from arguing anything to the contrary. But in the alternative, and this is very clever of Maryland, they say, well, Kalshi was right the first time. And here's why, and pointing to all those prior inconsistent statements that permeate two tiers of judicial proceedings in the D.C. Federal District Court as well as the D.C. Circuit. They didn't just say it once or twice or have it be an offhanded remark. It was a consistent theme that Kalshi advanced throughout that litigation. So from Maryland's vantage point, it's either judicial estoppel or Kalshi was right the first time.
Yeah, that was, I think that was the strongest part of the Maryland brief, near the end, just that litany they had of, all the times Kalshi said, we're game or sports are gaming and separate from elections and contrasting them with the seriousness and the consequences of election betting. Speaking of, there was this,
there was one statement that transcended that I was surprised that Maryland found it. But it was in one of the district court briefs in the District of Columbia where Kalshi actually said that if a contract violates another law, that instrument would be banned regardless of the special rule. So in that section of the brief, Maryland highlights the statement that really is almost equivalent to a concession that the CFTC regulation banning contracts that involve activities that are illegal under federal or state law. One of Kalshi's statements in the DC court seems to be consistent with how Maryland is interpreting Rule 40.11A1. So it really is a litany of prior statements that Maryland has now had the benefit of almost a month and a half of briefing, and they've really gone to school here with a magnifying glass and extracted every harmful prior inconsistent position that Kalshi advanced in the district court. And I guess it's safety by numbers, where if it's not judicial estoppel, it's just such an overwhelming presentation by Kalshi in the earlier case that it can't be viewed as anything more than Kalshi truly believing in that position at that time.
Yeah, and one of the things Kalshi did as a counterpoint to that Maryland point, they said in their reply brief that, hey, we never said that the sports contracts weren't gaming. We agree they're gaming, but they're swaps under the exclusive jurisdiction of the CFTC. And so I thought that was a clever pivot, back into their federal preemption argument. That was. You look skeptical. What do you think?
No, I'm not. I think they had no choice but to do that. Otherwise the credibility is strained. I mean, if you keep maintaining that up is down and down is up and east is west, at some point, just the sheer magnitude of all those positions, just sort of weighs heavily on the judge's thinking. And I believe their pivot was that yes, it is gaming, but the CFTC maintains the authority to determine under its own rulemaking whether those contracts are contrary to the public interest. So I think their navigation around that admission is really consistent with the argument that Kalshi has been maintaining all along, that the CFTC can make a case-by-case determination on the public interest. And admitting that sports event contracts are gaming is not fatal to the CFTC's ongoing discretion. At least that's how Kalshi views it.
Yeah, one of the things that I'm seeing collide here really are these two different attitudes about these parallel regulatory structures. So, if you look at the finance industry, for example, if you want to trade gold, you can do it as a commodity, under the CFTC, or you can do it on an exchange traded fund. That's a transaction overseen by the SEC. So same thing, you're trading gold, but you have these two different regulatory structures running in parallel. And in finance, it's great. It's deeper liquidity, it's greater flexibility for traders. Nobody in the gambling industry has ever said that about sweepstakes casinos or, gray market slot machines. Everything in gaming has to be under this very, strict regulatory structure, and just the one. So, throughout these cases, I think it's been interesting to see those two attitudes come to life. The gambling industry's, opposition to having these parallel products under finance that they already offer under gaming law. And, the finance industry saying, this is a perfectly reasonable offering, based on the needs that we're trying to give our, provide our customers, the hedging utility we're able to offer with these contracts.
Well, within the financial instrument sector, you have different, which I guess the overriding, connective tissue here is you have different federal agencies overseeing different types of financial products. I mean, that is, throughout the, Dodd-Frank legislation, you have this allocation between the CFTC and the SEC, where they stay in different lanes regulating different things instead of having overlapping or concurrent regulatory authority over the same product. Now, you point to the world of gaming where you have sweepstakes and all these other products, but those products are not regulated by anybody. They're gray market, black market, illegal products that fall outside of the regulatory scheme. In the state licensing world, there isn't just this one overarching set of laws. You have different regulatory frameworks under state law for horse racing, for casino gambling, for sports wagering, for fantasy sports, casino gambling, maybe even skill games. It might be state regulators, but they could also be different state regulatory agencies. You have horse racing boards that regulate horse race wagering, and you might have casino control commissions oversee casino style gambling, and then you have state lottery commissions that oversee lottery games, and in some cases sports betting. So it is kind of a parallel system of, or there are some similarities in that within state regulation and federal regulation, you have different areas of expertise that are responsible for regulating specific products that fall within that realm of expertise. But the sweepstakes analogy, or the products that are clear and clear, like illegal, at least in my view, they're not regulated by anybody, whether on the federal level or by the state level. And there's this movement afoot led by the Native American tribes to have state legislatures expressly prohibit these products as being contrary to state gaming laws and in violation of state laws. And there could be some lawsuits down the road, almost similar to what's occurring in the Kalshi context, where these envelope pushing sectors, whether they be prediction markets, sweepstakes casinos, DFS 2.0, the tension between the regulated and unregulated often will result in a court battle, and a court will have the final word.
Well, the other new frontier too is crypto. So if President Trump gives the CFTC the regulatory authority to oversee the cryptocurrency industry, I think an early test for Brian Quinten's is going to be SI Predict, Sports Illustrated, the brand and prediction market they have now. And in their FAQ saying, how is this legal? They flat out say, we are structured so that we avoid gaming regulation and financial regulation. And, a big part of Brian Quinten's belief system is that these event contracts should be traded on a licensed DCM, on a licensed exchange. And so one of the interesting outcomes you could have is, Brian Quinten supporting, Kalshi offering sports, but then does he also go after SI Predict for being an unlicensed exchange offering wagers that are too similar? I think that'll be really interesting to see whether he can do both.
The battle of the verbiage is been legion in the gaming industry, right? An entry fee or a daily fantasy sports entry fee is not a wager or a bet. A sweepstakes is a product promotion. It's not a lottery. It's all a bunch of wordplay and verbiage. And I think as much as you need gaming expertise, I think real good gaming lawyers should have a mastery of wordsmithing, because wordsmithing is at the heart of all of this. I mean, even in the Kalshi literature or Kalshi court papers, they refer to, they're not bettors, they're traders. It's not a sports book, it's an exchange. It's not sports betting. It's a financial instrument. It's a commodity. It's a hedging. I was on a panel in the Isle of Malta with one of New Jersey's preeminent sports betting lobbyists. And the first question that they posed to us was, tell me, is this, are these sports event contracts? Is it betting? And the guy who's like the champion of New Jersey sports betting said, no, it's hedging. That when you purchase a contract on whether the Yankees will beat the Oakland Athletics or the Sacramento Athletics, and you pay $1 or whatever, some low-level amount, you buy a contract basically choosing that the Yankees will win and it results in a payout. You're not betting, you're hedging. And you have intelligent people that are, depending on where their bread is buttered or depending on the outcome that they want, will stick to their story and remain consistent and ride that out until the end of the line, until a court conclusively holds otherwise. And that has been one of the biggest afflictions in the gaming industry, workarounds and wordsmithing in the name or under the guise of innovation. And we may be seeing that here, or we may not be seeing that here. But the beauty is that no matter what you and I say on this podcast, and what the parties are going to write in their briefs, ultimately, courts are going to come down and decide where the line of demarcation is. And ordinarily or typically, courts are always going to lean on applying form over substance. And that's a decision, or at least that's an interpretive tool, a common sense interpretive tool that could favor Maryland here. But again, even if a court decides otherwise, Congress could abrogate what a court decides by changing the statute to make crystal clear that swaps can include sports event contracts. So we're right now in step one. There's going to be a step two, a step three, a step four. There's always going to be a backup plan. And I think the final, I guess, hole card that the Trump administration or the CFTC can play while Donald Trump remains the president of the United States, where Congress is under Republican controls, they can always change the statute. That's obviously not the path of least resistance, but it's an option if the court cases do go against Kalshi.
Well, how soon are we going to get an opinion from the judge or decision from the judge in Maryland now that the reply briefs are in?
I think pretty swiftly. This is a motion for preliminary injunction. So a PI presupposes the need for emergency relief, that every day that Kalshi faces this threat, they're facing irreparable harm, and that the state might be facing some level of irreparable harm through the existence of these event contracts within Maryland borders. So I think the judge understands that there's some need for expediency here. He held the oral argument nearly a month ago, has already had the benefit of the guts of the parties' briefs. All those briefs were filed in May. This is just supplemental briefing, and I don't believe the supplemental briefing expands that dramatically at all, if at all, on the arguments that were previously presented to Judge Abelson. I think if he hasn't already made up his mind, he's certainly rounding third base on his way to home, and it's just a matter of writing up and sort of papering the opinion. And I think we're looking at within a 2 to 3 week window. Maybe with any luck, Chris, it will happen the day of your panel at the Nicolgees conference in Louisville, Kentucky, to give you some fresh material to talk about. But I think the timing of the decision should almost coincide with that conference in mid-July, and I would be surprised. I wouldn't be surprised if he rules before the end of the next week.
Man, that's coming up pretty quick. So what happens to the trajectory of these cases, do you think, if one, if Kalshi wins here, or two, if Kalshi is denied their preliminary injunction in Maryland?
If Kalshi wins again, and now has 3 out of 3, I think that could have a chilling effect on how some new states approach the issue. Because remember, back in March and April, there was this wave of cease and desist letters from not just the 3 states that ended up getting sued, but I think from 7 states overall. And we haven't heard anything since Kalshi scored its first victory in Nevada. So I think a victory in Maryland would probably put a temporary hold on any future cease and desist orders from new states, and would probably cause the other 4 states that have yet to be sued to relax some of the compliance deadlines until the first 3 cases, Maryland, Nevada, and New Jersey, run their course in the appeals court. So it could have a very favorable impact. A Kalshi victory would positively impact its ability to offer sports event contracts, not only in those 3 states where they're in litigation, but in the other 47 states where there's not even any litigation. They would probably face no short-term or near-term risk of having those contracts being declared to be illegal or enjoined by a federal court. So it would really fortify their business model, at least for the next number of months, if not a year or longer. Conversely, if Maryland wins, which I think is a better than 50% likelihood, based upon my reading of Judge Abelson's comments during the oral argument, he expressed skepticism as to a number of the positions that Kalshi raised with respect to economic circumstances and congressional intent. But this case will be decided. Before I get to the ramifications, we could talk about judicial estoppel. We could talk about any number of the rules in IGRA. This case ultimately is going to boil down to congressional intent. And when I say boil down, I'm stealing Judge Abelson's own words. And he said, ultimately, whether sports event contracts and not just wheat or oil contracts is something that can be offered on a derivatives market, that's going to boil down to one of congressional intent. And wisely, Maryland answered the call on that issue and dominated their supplemental reply brief and their supplemental briefing with congressional intent evidence, such as the legislative history, the existence of these other federal statutes, the notion that Congress, the old foundational rule that Congress does not fit elephants into mouse holes. Mm-hmm. And that analogy, I think Maryland went to town and feasted on congressional intent, whereas Kalshi was backpedaling and playing a lot of defense on the issue of judicial estoppel. And I believe in the supplemental briefs, Maryland more directly addressed the main issue raised by Judge Abelson. Tell me what the congressional intent was with respect to these types of contracts, not just all swaps, but sports contracts. And it seems to me that Maryland delivered the goods here on that issue with greater impact than Kalshi may have, and Kalshi was focused on a whole number of issues, including judicial estoppel. So what happens if Maryland wins? It takes the shackles off of all the other states. You could see the other 4 states that are in a holding pattern. I think Arizona, Illinois, Connecticut, and I forget what the 4th state was. I think they've extended the compliance deadlines while these other cases have been in litigation. If Maryland wins, it could precipitate drop dead dates being established, which puts Kalshi in a position of having to sue these other state governmental agencies. So what could become what are now three lawsuits could become 4, 5, 6, or 7 lawsuits, and it could cause other states to potentially issue cease and desist orders to Kalshi. It could open up the floodgates somewhat, but more importantly, from a legal lens, a Maryland victory is precedent. It's precedent that could be used in the 3rd Circuit. It's precedent that could be used in the District of Nevada. It's the most recent, presumably fuller examination of the legal issues in play, because I think the first couple of decisions were more run and gun, or did not take a deep dive on some of these issues. There was more like a lot of quick hits, and ultimately leading to the decision. Judge Abelson's ruling, when it results in a legal opinion, will probably have a smorgasbord of examination of the different issues with more comprehensive analysis. And it's possible that the law of recency will apply, and Judge Abelson's decision, whichever way he rules, will appear to be more influential to future courts based on the depth of analysis that he engaged in, which in part was driven by the depth of analysis brought by both Kalshi, Maryland, and by the Indian tribes, having the benefit of going last in the queue. They delivered more well-rounded, more deeply analytical briefs that hit upon all the issues in much more comprehensive detail than the New Jersey and the Nevada cases did. So I think that the upside and downside for the litigants from a Maryland decision is, I think, the momentum shifts or continues based on this ruling, because I expect it to be the most thorough and respected opinion based upon the ground I anticipated covering.
That makes a lot of sense. I mean, this is going to be a huge crossroads for these cases in general. Well, anything else before we wrap up and sign off, or you think we hit everything?
Well, strangely, Judge Abelson was sued by the Trump administration 2 days ago. The entire federal judiciary of Maryland was sued by the Trump administration over a standing order that prevented any further deportations of individuals who are claiming, habeas corpus rights. And it was a standing order issued by the chief judge. And I think Judge Abelson had handled one of those cases. So Judge Abelson has been sued by the Trump administration, and he's deciding a case in which the president's son is a strategic advisor to Kalshi. So I don't think that impacts anything, but it's interesting to me that he finds himself in the crosshairs of the Trump administration at the same time in another matter that the Trump administration's policymaking or lack thereof is at issue in the Kalshi case. Very interesting set of circumstances. But this decision, whenever it's rendered, I think either shifts the momentum or just continues Kalshi's unprecedented and surreal 3-court winning streak. But to me, the turning point, which was that day last week when all these groups filed amicus curiae briefs in the Third Circuit U.S. Court of Appeals, groups that never agree on anything, tribal casinos, commercial casinos, states, problem gambling advocates, they all joined hands and filed an amicus brief in the Third Circuit. And I think that could have been the major turning point in all of this going forward. But of course, nothing resonates quite like a judicial decision. So I'll wait and see how Judge Abelson rules. I tend to think he's going to side with the state of Maryland. That's the way he appears to be leaning. And if Maryland can't win when they've had Kalshi on the ropes, I don't know if it bodes well for any of the future decisions. I think if Kalshi wins here, it fortifies their position going forward in almost every other jurisdiction. There is a lot on the line for everybody here, not just the states, not just the tribes, but for Kalshi, which just did a major raise yesterday based on a $2 billion valuation. A negative outcome could have an adverse impact on the perceptions around its scalability in the world of sports gaming.
And the intrigue never ends with this administration and these companies and these lawsuits. So that's, I think, everything we can cover for Prediction News Update today. We'll leave it there for now. I'm sure there'll be something to talk about as early as tomorrow. We'll see. But, welcome. Thank you for coming to Prediction News Update. If you like what we heard or like what we spoke about, like and subscribe. And you can follow our reporting at predictionnews.com. Dan, as always, thanks for doing this.
Thanks for having me back again. I always enjoy doing this with you. Thanks again, Chris. Thanks, everybody.